Hi guys, welcome to my channel Legal number 1. Today we read and teach landmark United States Supreme Court cases. Marbury, Madison, 1803. Issue who can ultimately decide what the law is. Result: it is strictly the province and duty of the judicial department to say what the law is. Important, the decision give the court of liability to strike down law on the grounds and they are unconstitutional power called judicial review. MC College v. Maryland 1890 या 1890 issue can courts establish a national bank and if so can a state tax this bank. Result: the court held that Congress had implied power to establish a national bank under the necessary and proper closure of the US Constitution. The court also determined that United States law trumps state law and Constitution a state could not tax the national bank. Importance: the McLaw decision established two important principles for constitutional law and continue today: implied power and federal supremacy. Gibbs, Oregon, 1824. Issue can state pass law that challenge the power of Congress to regular insurance conference. Result: the court held that it is the rule of the federal government to regular conference and state government cannot develop their own commerce regular law. Further, the court created a wide definition for commerce, recognizing that the term encompassed more than just selling and buying. In this case, the court determined and regulating water navigation was in fact an act that regulated commerce. Importance: the impact of the Gibbons is still felt today as it gives the federal government a much broader base to regulate economic transactions. Dred Scott with Sanford, 1857. Issue in this pre-Civil War case, the question was whatever Congress had to constitution power of profit salary in the free trades, and the second question was whether the constitution gave the African American the right to sue in the federal court. Result: The 1857 court also no on both accounts. Congress could not profit salary and Titirius and African American also had no right to the sue in federal court. In reaching these answering the court interpretation the Constitution as it excited before the Civil War Amendment Constitution Amendment 30, 40 and 50 apologize Constitution the people of African decision had known of the right of citizen that court further responded that slaves were property and therefore could not be taken from their owner without due process. Important, the Dred Scott case became a central issue in the debate, surrounding the expansion of slavery and further fueled the flame leading to the Civil War. Shakespeare, United States, 1990. Issue the content speech including citing an anti-war pamphlet a drafted man made in wartime in damned is violation of the Espionage Act protect the First Amendment. Result, no, although the defendant would have been able to state his views during ordinary time, the court held that in the certain circumstances like this case, the nation beginner at war justify such limit on the First Amendment. Importance, the Shiknik decision is best known for certain the clear and present danger test, meaning that speed could be restricted. It is presented clear and present danger. The decision was also the first to explain the metaphor of falsely yelling fire in the crowd there. Shink was later modified by the band burning Ohio, which said the speed could be restricted. It would provoke immediate law action. Brown with Board of Education 1954. Issue, do racially separated public school violate the equal protection clause? Result, yes. An anonymous court overturned Plessy, Ferguson and held that the state law recording or allowing the racially surrogated school violate an equal protection clause of the further than immediate the court famously state separate education facilities are immediately equal. Imported, the Brown decision is held to landmark decision in Supreme Court history, overruling Plessy Ferguson in 1896, which had created the separate but equal decorine is Plessy. The court sorry held that even throughout the Louisiana law required rail passenger be segregated based on race. There was no violation of the 14th Amendment equal protection clause, so a long accommodation it issue were separate but equal. By overtaking this doctrine, the Brown Court helped lay the ground for the civil rights movement and integration across the country. Gordon Wainwright 1963 issued the Constitution required that any individual charged with a felony but unable to pay for a lawyer be granted the fees assistance of legal counsel. Result. Yes, according to an anonymous Supreme Court, the court held that the Sixth Amendment right to assistance to counsel applies to criminal state trials and that lawyer and criminal courts are necessary not luxury. Important along with the right to assistance for state criminal defendant, the Gideon decision had the effect expanding the public defender system across the country. Mirandaville, Arizona, 1966. Issue are sorry हमारे भी sorry Miranda Arena 1966 issue our police constitution required to inform the countryside by countryside by through right to the remain silent and silent and to the attorney result. Yes, the court found that the further and Sixth Amendment requires police to inform individual in custody that we have right to remain silent to be consistent to the attorney according the court is further by the courts could not the admitted evidence during trial. Imported the law famous Marylanda warning the required before any police the evidence obtained during the interrogation going to be used during the trial. The court limited and award this warning over the years. think with Des Moines 1969 issued as the first amendment prophet school of official from barring student from working black and banned the symbolize the anti-war political protest. Issue can the institution the higher learning race factor when making the administration decision. Result: the court held the university that used the part of the admission process along fixed quits or not issue. The court determined that the specific system of the legal constitution advisory student body was merely fixed quota, the therefore was unconstitutional. Important the decision state of the case with the court upheld unfortunately action program in 2003 which academic affirmative action program was again directly challenged to Dred billion and greater the includes the race factor pass constitution muster along with the policy narrowly railroad and does not create automatic preference based on race. The court arrested that the system created automatic race based preference would in fact violate the equal protection clause. So guys, today we read and teach USA landmark United States Supreme Court cases. So please like and subscribe my channel and bell icon. See you again next time. Bye bye.